Well, the short answer is yes, but you should be somewhat cautious before doing so. There's been a lot of discussion over whether amendment is permissible at all. Per NAR's guidance on the practice changes, buyer broker agreements can generally be amended if both the buyer and the broker mutually agree to do so. This is consistent with freedom of contract principles embedded in the common law. But as with most things, there can be exceptions and other instances where amendment may not be the best idea. Let's talk about consideration first. Under Oklahoma law, for a contract to be enforceable, there has to be consideration by both parties. This consideration requirement is also generally applicable to amendments of a contract. Consideration in this context means that both sides of the agreement have to exchange something of value in order for the agreement or the amendment to be valid. So for example, let's assume that you have a situation where a buyer-broker agreement has been signed and the broker is now providing services for the buyer. The broker then comes across a property where the amount of buyer-broker compensation offered by the listing broker or by the seller is more than what the buyer's broker already agreed to accept. Can the buyer and their broker amend this agreement to enable the broker to accept this additional compensation? Well, this depends in part on whether there would be good consideration for the amendment. If the buyer's broker is not agreeing to alter their services in any way and is simply accepting more compensation, then there's a chance that the amendment would not be enforceable if there's not mutual consideration. So, if you're going to pursue an amendment to a buyer-broker agreement, you should make sure that both sides of that agreement are providing something of value with respect to the amendment. You should also make sure that you're not using amendments to circumvent the purposes and spirit of the NAR practice changes. For example, imagine that a buyer-broker signs a buyer-broker agreement where they agree to accept an absurdly low amount of compensation, with the intent of just amending that agreement later once they learn how much is actually being offered by the seller or the listing broker. That's a very bad idea. The MLSs are responsible for enforcing these practice changes, and I think it's likely that such behavior would be viewed as an attempt to circumvent the practice changes. The takeaway here is that this is not something to get cute with. Instead, know your value on the front end and negotiate your true compensation with the buyer at the outset of your relationship.